Right. Welcome to Epitome IAS. So it is a part of a series of videos and series of live sessions regarding the answer writing program. How to write answers, how better we can write answers, and how to critically think about the answer. All these dimensions are clearly explained in this video. Okay. Right. So let us take the question from 2024 General Studies paper 2, where it says that explain and distinguish Lok Adalat and arbitration tribunal, whether they entertain civil as well as criminal cases, right? So basically, why this kind of questions are asked? These kind of questions are asked in the context of governance paradigm, okay? Particularly in the light of the impact of the liberalization, privatization and globalization. Obviously, the state has to entertain alternative dispute resolution mechanism in order to promote ease of doing business, in order to ensure the litigation free society. The litigation must be cleared in the society, and the business environment must be created, okay? So the ease of doing business must be created, ease of living must be ensured. So for that requirement, we cannot go only through the traditional methods of dispute resolution mechanism, that is judicial dispute resolution mechanism. In the of course, we are not replacing the judicial dispute resolution mechanism, rather we are promoting an alternative dispute resolution mechanism. So it is a choice of the people. End of the day, the development according to Amartya Sen is what? Development means enhancing the choice and ability of the people. Choice and ability of the people to enhance their living quality, right? This is how we got the question. Explain and distinguish Lok Adalat and arbitration tribunals. Okay, Lok Adalat and arbitration tribunals, right? So how to approach this answer? Okay, so obviously what should be the introduction? Okay, so introduction must be a general introduction, okay, which must be introducing the concept of Lok Adalat as well as arbitration tribunal, right? So let us say here Lok Adalat and arbitration tribunal, arbitration tribunals are part of alternative dispute resolution mechanism. Lok Adalat and arbitration tribunal are part of arbitration, or what is that, alternative dispute resolution mechanism, where they will offer comparatively quick, accessible and cost effective justice. Okay, so this can be our introduction, right? Because it is just 10 marker question, we do not require to write more than this, okay? Cost effective justice in the country, okay? And let us also understand what is other dimension. What is it? Explain and distinguish Lok Adalat and arbitration tribunal, okay? So in the body of the answer, we require to explain what is Lok Adalat and what is arbitration tribunal, right? So let us understand about what is Lok Adalat here, okay? Let us write, okay? Here Lok Adalat has been established, or the Lok Adalat has been provided under NALSA Act of 1987, NALSA Act of 1987, okay, right, which is an alternative dispute resolution mechanism. alternative dispute resolution mechanism, right? And Lok Adalat, it is headed by a judicial officer, and other members include social worker and a senior judge, senior advocate, a senior advocate, okay? And the primary function of the Lok Adalat include, the primary jurisdiction of the Lok Adalat include civil cases or civil matters, public utility services, okay, as well as compoundable criminal cases. So this is what the jurisdiction of the Lok Adalat, okay. Then we need to explain what is arbitration tribunal. Arbitration tribunal. So arbitration tribunal is also, it is also a form of what is an alternative dispute resolution mechanism, okay. Arbitration tribunals are established as per Arbitration Act, Arbitration and Conciliation Act of 1996, okay, right. Arbitration Conciliation Act of 1996, okay, right. The arbitration tribunal can be single membered or multi-membered. That means an arbitration tribunal can be individual, okay, it can be an individual tribunal or institutional tribunal, institutional. So there can be individual arbitration or institutional arbitration, right. Then it is generally limited to those business agreements which have arbitration clause. Only when arbitration clause is there, such matters can be referred to arbitration tribunal, okay, right. So and arbitration tribunal functions under the regulatory body called as Arbitration Council of India. So this is how we need to write answer, okay, right. And if you try to look at this particular Lok Adalat also, we can write another point, okay. The awards of Lok Adalat are binding on both parties, okay, binding on both parties, which cannot be challenged in any court, which cannot be challenged in any court, okay, right. So we have explained what is Lok Adalat and what is arbitration tribunal. Lok Adalat has been created as per NALSA Act of 1987, as well as arbitration tribunal has been created as per Arbitration and Conciliation Act of 1996, okay, right. So we need to distinguish how Lok Adalat is different from that of the arbitration tribunal, okay. So Lok Adalat, so I am not getting into the definitions or terminology because it is just an answer writing format, hence I am writing down the answer directly, okay. Lok Adalat and arbitration tribunal, okay. So if we try to distinguish this, first point, it is a mechanism, it is an alternative dispute, ADR, that is created under This mechanism is created under NALSA Act of 1987. NALSA Act of 1987. NALSA Act of 1987. Then this is created under Arbitration and Conciliation Act. Arbitration and Conciliation Act of 1996. Arbitration and Conciliation Act of 1996. Then it uses primarily, it uses conciliation as a mechanism. Conciliation is a mechanism. What is conciliation? A third party mediates between two parties in the dispute, and he will be helping actively to resolve the dispute by arriving at a particular solution which may be acceptable to both parties. That is what called as conciliation. Whereas arbitration, actually this is of course the very name indicates, it generally undertakes arbitration as a mechanism. Arbitration. Okay. So arbitration means what? A third party involves, and his award is binding on both parties, whether the both parties may like it or dislike it. They cannot challenge in the court except in certain conditions. Okay, that is what called as arbitration. Okay, right. So this is available for civil and criminal matters, but criminal matters must be, what is it? Compoundable. Compoundable means those cases which can be settled outside the court, which are mild in nature, which are non-serious offences. But here only business and commercial matters. Business and commercial matters. Right. So Lok Adalat generally functions under the authority of judiciary. So judiciary mediated. It is judiciary mediated or judiciary controlled. Okay. Here Lok Adalat, arbitration tribunal functions under an independent body, independent regulator, that is Arbitration Council of India. Arbitration Council of India. Right. And what else we need to understand? Moreover, this particular, this Lok Adalat, this can be, the matters can be both at pre-litigation stage or post-litigation stage. So it means the matter might be under the active consideration of court, or matter might not be referred to the court. But in the arbitration tribunal, the matters have no connection with the court. The matters have no connection with court. Okay, and there is a composition, difference in the composition between these two, right? If you try to see the composition, just now I told you, judge plus social activist, social worker plus senior advocate. So this is what the composition. But here the composition will be, he is an arbitration professional. He is an arbitration professional recognized by Arbitration Council of India. Recognized by Arbitration Council of India. Right. Then what else we can understand? Right. So Lok Adalat does not follow procedural law. Lok Adalat does not follow procedural law. it follows only substantive law, only substantive law is followed. Okay, and this is what the common point here. Arbitration tribunal also does not follow any procedural law, any procedural law. So this is how we can understand. Okay, right. So these are the broader differences. Okay, right. So this is sufficient for a 10-marker question. Okay, right. Then what is the next aspect of the question? Whether they entertain civil as well as criminal cases. Okay, of course we have explained simultaneously. Let us also write as a new dimension. Okay, right. What we need to understand: Lok Adalat can entertain non-serious and petty offences, which are compoundable in nature, whereas serious offences are non-compoundable offences are out of the purview of Lok Adalats. Okay, right. So here Lok Adalats can be found at various levels, at Supreme Court level, High Court level, local court level, like that. Very different types of Lok Adalats are available. But here arbitration tribunal is arbitration tribunal. You cannot be saying it is a national, regional and or local. Okay, we can write this point here. Okay, no regional classification, arbitration tribunal. But here Lok Adalats can be considered at union level, state level and district level. So there can be different types of Lok Adalats, and there are also certain Lok Adalats which are called as permanent Lok Adalats, so which have been created by the amendment of the NULS Act. Okay, right. So that is how. And whereas arbitration tribunals exclusively focus upon business or commercial disputes, business and commercial disputes, and they do not entertain any criminal matter, because their purpose of establishment is not to resolve the criminal dispute. Moreover, why both Lok Adalat and arbitration tribunal do not deal with either criminal disputes or serious matters? Basically the criminal law is a public law, and crime is an offense against the society, not just an individual. So naturally, what is the obvious consequence? The obvious consequence is that the state has to ensure its responsibility. How the state ensures its responsibility? By bringing the culprit to the justice. That is what the state's role. Hence, state cannot allow the compromise of these cases through Lok Adalat or arbitration in out of court settlement manner. But however, Lok Adalat can facilitate the compromise of the non-serious offences what is that, compoundable offences, petty offences. But at least that relief is not available under arbitration tribunal because their focus is just upon business. And moreover, the criminal law is public law, crime is an offence against society, hence state has to ensure its responsibility by bringing the culprit to the justice. Hence it does not leave any scope for compromise. Out of court settlement is not possible in the case of any serious offences. Okay. So this is how we broadly write the answer. Okay. And then in the conclusion, what we need to write, right? The conclusion. So we need to summarize all these things. Okay. Thus, both Lok Adalat and arbitration tribunals will help in resolution of disputes in the manner which will promote the justice which is client centric, informal and cost effective. Okay. Further both can facilitate and promote ease of doing business as well as taking forward the objective of minimum government and maximum governance. Thus the choice of the people is increased. So according to Amartya Sen, development, I told you already, development is nothing but enhancing the choice and the capability of the people in order to enjoy decent life. So this is how this Lok Adalat and arbitration tribunals are promoting the society which will be having minimal litigation. Okay. And further they will be helping in reducing the pendency of the courts. Okay. Right. So I think you are able to follow what I have discussed in the class. Right. So this is so. So this is what introduction. Lok Adalat and arbitration tribunals are part of alternative dispute resolution mechanism which will offer comparatively quick, accessible and cost effective justice. Lok Adalat has been provided under NALSA Act. We have explained about what is Lok Adalat. We explained about what is EDR, and in the further aspect of the answer writing we have explained what is the difference between Lok Adalat and arbitration tribunal. Thereafter we have explained, okay, whether they generally resolve the criminal disputes or not, and we have concluded this way. What is that conclusion? Thus both Lok Adalat and arbitration tribunals will help in resolution of disputes in a manner which will promote justice, in a manner okay, which will promote justice which is client centric, informal, cost effective, and further both can facilitate and promote ease of doing business as well as taking forward the objective of minimum government, maximum governance. So I think you are able to understand how to write an answer. Okay. So please follow the YouTube channel of Epitome IAS and Telegram as well, so that you will get valuable inputs, because when you frequently watch the videos, definitely you will internalize the quality of answer writing. Okay. Don't miss the videos, and we are providing very good content comparatively. Hence try to follow this channel and for your own betterment. Thank you.